Hello, I'm attorney Dan Marr here in Nashua, New Hampshire. I've been practicing in New Hampshire for approximately 36 years and in the Commonwealth of Massachusetts for approximately 28 years, licensed and practiced in both states. During that period of time, I've dealt with a lot of unmarried couples, breakups, and what happens to the real estate that they own together. And I'm going to be focusing primarily on New Hampshire today. But in that situation, I've had situations where a client comes to me and perhaps she says she moved out of the house because she's been with her boyfriend or significant other for 20 years, and they've shared the expenses equally. There's really no question that they both own 50-50 in regards to the property, but he doesn't want to sell. He's saying, look, the mortgage rates are high. I can't afford to buy you out, maybe because he has to not only he needs to figure out a way to purchase the property and say it doesn't even have a mortgage on it. It's just straight out. So say the property is worth, in this market, it could be $600,000, $800,000 or more. And he doesn't have the ability to do that or to finance that mortgage. So he's saying, look, I can't do that, or he's pushing it off. And you really aren't even having a fight as to your percentages. What should you do? I would strongly recommend filing a partition action. In New Hampshire, we have a statute that you can file it in both the Superior Court or the Probate Court, but it's a action where you divide up the property. It gets more complicated when somebody's not on the title of the property. It also gets more complicated if there's a dispute between what percentages the parties have, because certainly the court can make a decision that one party has 40%, the other one has 60%, or in some situations, I've had cases where it was a very short-term relationship and they just were put on the deed and the court says you have zero interest because he paid everything or she paid everything and you just were put on because you were expecting to get married and you didn't get married. So it was a 6-month-year relationship and the judge says you get zero on it. So those are more complicated. I've litigated those cases as well as resolved those cases. But even in the simple matter where you both are agreeing that there's really no fight as to you both owning half each because you've been in the relationship for 20, 30 years and you've both been sharing equally on the property, so there's really no fight on that. And I can tell you if you're in that type of relationship for that type of period of time and you have been contributing really close to the same, you're more likely going to get a 50% equity distribution on the matter. But to force that issue, to get it actual, so the person that's still living in the property has to sell, the partition action makes sense because the court's going to do one of two things. Either the court's going to, in ordering the distribution, say that the person has the opportunity to buy out the other one, and if he doesn't, then the sale is going to happen with a cooperation, and if they don't cooperate, come back to the court with hiring of a broker, showing the property, all of those things. And if he's in the property and he's still being recalcitrant and not working in this, he could be found in contempt of court. So that can force the issues, and you need to force the issues, because in those situations you need to push the ball, advance the ball down the court, and the only way, pardon the pun, but the only way to do that is to actually go to court and file the action. A lot of these partition actions get resolved. I've had several of them where I've just filed the actions and the matters are resolved quickly with the other side, and I've had other cases that the other side gets counsel and we do a little bit of discovery and resolve it beforehand. And then we actually have cases where there are trials too. But they're fairly simplistic matters unless there's other side issues involved in the matter. So it can be tried fairly effectively. And again, most of these cases settle, but you need to push it so that the other side that's living there and saying, I like this arrangement, I'm only paying maybe there's no mortgage, so I'm only paying utilities and the taxes, and I can handle this, and I don't want to sell it. I like living in this big house. I don't want to sell it. You can force that issue, and then you can sell the property if he can't afford to buy you out as the person that left, and that's the way to do it. So I've dealt with these cases quite a bit. I'm Dan Marr at Hamlin Kerrigan in Nashua, New Hampshire. My telephone number is 603-883-5501, 603-883-5501. And I both brought these actions and defended the actions. Usually when you defend the action, you also do a cross motion to partition so that you know that the property is going to be divided one way or another, similar to a divorce. When a divorce, they'll cross petition because they don't want the other side to just give up, and then you're stuck with the beginning of the process, because you generally will want in a partition action both sides eventually are going to want to force a resolution where one of them is no longer in the property. And also, just so you, as a side note, when you do these transactions with the settlements, when one's buying out the other, the person that's being bought out will be giving what's called a quitclaim deed, saying whatever I have, I'm giving to you. So I didn't create any other liens on this property, and I'm giving it back to you, rather than what's called a warranty deed, where you're warranting title. Because in that situation, he already has 50% of the property, and you're just giving him what you have in the property. Again, Dan Marr, 603-883-5501. You can also check out our website, NashuaLaw.com, NashuaLaw.com, and my weekly blogs are in there. So you can look at this topic and a variety of other topics. Look forward to working with you if the opportunity arises. Thank you.